Interim order has come in. The Chief Justice of India has begun dictating that interim order in the courtroom. It says, during course of hearing, the Solicitor General has stated that the union would like to put a response within 7 days. He further said he assures the court no appointments will be made to the council and board under section 9 and 14 till the next date of hearing. Waqf, including Waqf by user already registered or declared by way of notification, shall neither be denotified or the collector will change. We take the statement on record. So on that assurance, of course, of the Solicitor General, obviously there is no sort of interim stay put yet, but they are taking the the point put forth, the assurance given by the Solicitor General on record in this interim order, Brian.
Well, clearly, again, I'll start off where you just left off and where I just left off. Clearly, this CJI clearly stated in the end that he is sure that there are and Hindus are opposing this legislation. And now, as for breaking also that you have clearly mentioned, that definitely interim order. Now, during this very case of hearing, the SG clearly stated that the union would like to now put a response within 7 days of this. That even was said by the SG just a while back when we were talking. Now, he also further elaborated and said that he assures that the court, no opponent will be made to the council and board under the S.9 and 14. And till that very moment also, till the next date of the hearing, Waqf will, including Waqf by user, already who are maybe already registered or who have already put a name on it, or are even declared by way of notification, shall neither be denotified or the collector will clearly change or have a different altogether meaning. But they take this very statement on record. So definitely a big statement saying that they have taken this very statement on record itself. And now clearly also there, so the CJI has said, as far as writ petitions are concerned, they only want 5 writ petitions, and it is impossible to deal with 100 or 120, and others will be treated as disposed of. And then the CJI also continues to say that they are not going to refer the names.
In fact, the Chief Justice of India goes on and says, as far as writ petitions are concerned, we only want 5 writ petitions. It is impossible to deal with 100 or 120. Others will be treated as disposed of. Chief Justice of India also says, we're not going to refer the names of the parties. We will refer to it as Waqf Amendment Act as name of the matter. So another important order, of course, given by the Chief Justice of India in terms of the number of petitions pending on the same issue before it, Brad.
Well, clearly, like I even mentioned, yes, clearly the CPA has said as far as the writ petition, 5 is still okay, but he clearly says that it is impossible to deal with 100 or 120 petitions, and they will be, these others, the remaining ones, will be treated as disposals of. Now, very importantly, he even said that we are not going to refer the names of the parties, but he will be referring it as Waqf Amendment Act as name of the matter. And then the CJI has also said to appoint nodal councils, very importantly to appoint nodal councils. And so the Sibbal also said that, my lord, must be declared or registered, including Waqf by users also, so that even Sibbal has made a counter. And then CJI has said it includes Waqf by user itself. Uday.
Absolutely. In fact, of course, this is a big statement being made by the Chief Justice of India so far. They're also, of course, asking the centre to appoint a nodal council now as well, Brian, reportedly.